Welcome to Major in Law YouTube channel. Let's go to the part 2 of the negligence lesson. Negligence as a non-criminal offense. Negligence is not a criminal offense. It is a civil wrong that is actionable in a civil court. The person who suffers the harm can claim damages. Criminal law deals with behavior that is prohibited by the state and is punishable by the state. Negligence, on the other hand, is a failure to exercise the care that a reasonably prudent person would exercise in a similar situation. It is more about compensating for the harm caused rather than punishing the wrongdoer. Negligence definition. Doughty v. Turner Manufacturing Company, 1964. Lord Diplock defined negligence as the application of common sense and common morality to the activities of the common man. Negligence entails more than heedless or careless conduct. It connotes the complex concept of duty, breach, and damage. In the context of the tort of negligence, just demonstrating that a defendant is careless is insufficient. It must involve a breach of duty that results in reasonably foreseeable damage. Structure of the tort. Lochgelly Iron and Coal Co. v. McMullan, 1934. Negligence in legal terms goes beyond simple carelessness and encompasses the complex concept of duty, breach, and damage. The definition of negligence includes three key components: duty, breach, and damage or injury suffered as a result. Simply proving that a party was careless is not sufficient to establish negligence in the legal sense. Lamb v. Camden LBC, 1981. The quote from Lord Denning emphasizes the various ways in which a ruling can be structured to limit compensation for a wrongful act. Judges may use different devices to limit compensation, such as limiting the range of persons to whom a duty is owed or claiming that the consequence is too remote to be ahead of damage. Ultimately, these devices are seen as tools for the judges, but the decision to limit compensation is considered a question of policy for the judges to decide. Policy. The courts have limited the scope of liability to prevent inconsistency and uncertainty. Certain categories of harm or loss and groups of defendants are excluded from negligence liability based on policy. Public policy dictates that a defendant is only liable when the results have broader societal and economic implications. Policy plays a significant role in the evolution of the duty of care in negligence and reflects the real public sense of justice. Duty of care. The duty of care is essential to establish liability in negligence cases. Certain relationships, such as between an employer and an employee, already have a duty of care established. The duty of care encompasses the responsibility to prevent harm and injury to others. Lack of duty of care can result in liability for damages and losses caused by negligence. In legal terms, duty of care is a legal obligation to act in a certain way to prevent harm. The function of duty of care is to limit liability for careless interactions and to allocate losses fairly in society. Development of the duty concept. Evolution of the tort of negligence. Impact of Donahue v. Stevenson, 1932. The neighbor principle defined by Lord Doughty. Establishment of the duty of care. Application of the duty concept in modern law. The foresight test. The neighbor principle established by Lord Doughty in Donahue v. Stevenson case sets a standard for the duty of care based on foreseeability of harm. The love your neighbor rule in law translates to you must not injure your neighbor in the context of legal liability for negligence. My neighbor in the legal context refers to persons who are closely and directly affected by certain acts or omissions, and whose harm could have been reasonably foreseen. The foresight test entails the obligation to take reasonable care to avoid actions or inactions that could foreseeably cause harm to others, even if the harm is not directly anticipated or intended. The proximity test. The word proximity refers to the relationship that exists between the parties and the circumstances that give rise to a duty of care. When it is reasonably foreseeable that someone may suffer harm if care is not exercised, a duty of care is established. However, the duty of care is not always owed. For example, in the case of Sutradhar v. Nurk, 2006, the defendants were found not to have a duty of care despite the harm caused. Legal principle and policy. The Doughty test was initially presumed to be sufficient in resolving duty or no duty in negligence lawsuits. Foresight and proximity. the twin concepts in negligence cases, were found inadequate in determining some economic losses caused by negligent acts. An additional factor had to be introduced to the ACI test to keep the duty concept performing well. In Ans v. Merton LBC, 1978, Lord Wilberforce introduced policy factors in the duty test, which led to two levels of the test: principles of law and policy. Wilberforce's criteria established that although there may be a duty of care, policy factors could work to reduce that duty. Wilberforce's approach was criticized for separating principle and policy, leading to two adverse consequences: expanding liability and separating essential duty factors. Caparo Industries plc v. Dickman, 1990. Principles of incrementalism. The case is a cornerstone for the incremental approach to duty of care, emphasizing the need for foresight, closeness, and consideration of circumstances causing injury or loss. Application of Caparo. Every particular circumstance should be given proper weight, and there should be a specific inquiry to determine the existence of a duty of care. Caparo test establishes a three-part test for duty of care: foreseeability, proximity, and fairness. Foreseeability: the first criterion requires that the harm be a reasonably foreseeable result of the defendant's conduct. Proximity: the second criterion looks at the relationship between the parties and whether there is a close enough relationship for a duty of care to arise. Fairness, justice, and reasonableness: the third criterion requires that it is fair, just, and reasonable to impose a duty of care. Alternative test establishes a three-part test for duty of care: foreseeability, proximity, and fairness. Foreseeability: the first criterion requires that the harm be a reasonably foreseeable result of the defendant's conduct. Proximity: the second criterion looks at the relationship between the parties and whether there is a close enough relationship for a duty of care to arise. Fairness, justice, and reasonableness: the third criterion requires that it is fair, just, and reasonable to impose a duty of care. Duties of lawyers. Immunity from negligence claims. Lawyers historically had immunity from negligence claims in court cases, as seen in Rondell v. Worsley, 1969, until changes in society led to the elimination of this exemption. Duty of care in financial transactions. Lawyers are not immune to negligence claims outside the court. In Steele v. NIM Limited, 2018, a solicitor's negligent representations led to significant financial losses, highlighting the duty of care in commercial transactions. Duty of care to unborn children. The Congenital Disabilities, Civil Liability Act of 1976 established a duty of care to unborn children for damage inflicted before their birth. The Act includes measures to safeguard children born with impairments as a consequence of damage to the mother during pregnancy or physical injuries to a pregnant woman as a result of an accident. No action can be taken if the negligence caused the infant to be born but did not cause the impairments. Liability may give rise only if the injury causes the baby's impairment after it is born. Duty of care to employees. Employees are not made unsafe by unsafe premises, harmful equipment, or incompetent co-workers. Employers are responsible for taking reasonable care to ensure employee safety. Discussion of the employer's liability for employee injuries. Key points you'll remember. Negligence is the failure to exercise the care that a reasonably prudent person would exercise in similar circumstances. The basic principles of negligence are duty of care, breach of duty, causation, and damages. Duty of care is a legal obligation to avoid causing harm and is the foundation of a negligence case. Examples of duty of care exist in various professions, such as healthcare, where practitioners are expected to provide a certain standard of care. Thank you for watching the video. For more content, subscribe and visit to Major in Law website.